the Legal Corner podcast series. Welcome to today's episode of The Legal Corner, a podcast which covers a variety of legal issues to keep you informed. Hosted by attorney-at-law Colin Denoon and communications specialist Leonardo Torres.
Thank you for joining us for another episode of the Legal Corner podcast series. I am your host, Colin Denoon, attorney-at-law, and I'm happy to be with you for another episode. My co-host, Mr. Leonardo Torres, won't be here today because of work commitments, but have no fear. I'm happy to bring you another engaging and stimulating episode. To all our regular listeners, we say thank you for your continued support. If you are listening to this podcast for the first time, you may be wondering, what is the Legal Corner podcast? Well, the Legal Corner podcast series is a bi-monthly show originating in the Tun Island Republic of Trinidad and Tobago and is aimed at providing you with insight into various aspects of the law. In today's episode, we'll be looking at the pros and cons of the CCJ. The Caribbean Court of Justice was established in 2001 and inaugurated in the year 2005. The court has both an original jurisdiction and an appellate jurisdiction. In its original jurisdiction, the court is charged with interpreting the provisions of the revised Treaty of Chaguanas, while in its appellate jurisdiction, it serves as the court of final appeal in both civil and criminal matters. For those countries that have abolished appeals to the Judicial Committee of the Privy Council. In Trinidad and Tobago, there is currently a motion before the Parliament seeking to make the CCJ our final court of appeal, and there have been a lot of discussion in the public domain about whether this should be done or not. Joining me on the show today to discuss this topic is Mr. Rico Yearwood. Just to tell you a bit about Rico before I bring him on, Rico Yearwood is a Barbados-based attorney-at-law. He graduated from the University of the West Indies Cable campus with a Bachelor of Laws degree, first class honors. He is also a graduate of the Yearwood Law School. He is the holder of an honorary first degree diploma in comparative philosophical study of law from the Moscow State University of International Relations in Moscow, Russia. Rico is a public law scholar with a Master of Laws in Public Law from the University of the West Indies Cable campus. He is the co-producer and co-host of the award-winning CARICOM Public Law podcast. His practice focuses on public law, and his main areas include Caribbean integration law, constitutional law, human rights law, and administrative law, including contentious and non-contentious. Rico is the head of the CARICOM Attorneys-at-Law Legal Research Department, and he is significantly invested in mentoring and tutoring law students. Welcome to the Legal Corner, Rico.
Yes, thank you very much, Colin, for having me, both you and Leonardo. I must say at the outset that I know in the wake of the recent ruling of the Judicial Committee of the Privy Council in relation to the mandatory death penalty, where they reaffirmed the constitutionality of that death penalty, that this is now a hot and topical issue, because it then brings back into sharp focus the debate surrounding the suitability of either court, the Privy Council or the CCJ, as a final court of appeal for all Commonwealth Caribbean countries. And because the topic is such a hot one right now within the Caribbean region, I am truly honored and humbled that out of all the guests you could have chosen, you chose me to discuss this one. So I'll try my best to have it as engaging and interesting as possible to live up to your expectations.
Thank you very much, Rico. And you are one of the guys, just following you on LinkedIn and so on, I realized that you were very passionate about this whole topic of the CCJ and acceding to this final court of appeal. So hence the reason the invitation was extended to you and you graciously accepted. So we're going to jump right in. And I want you to tell us a bit about the process for the appointment of judges to the CCJ.
Yes, so I think, Colin, that this is a very important point of departure. And I usually tell people that the process of appointment for judges to the CCJ is a simple but yet unique one. And I will explain why I refer to it as unique very soon. But I think that we must first appreciate what is the sole body that is responsible for selecting the judges of the CCJ. And I deliberately use the word select because I also have to frequently remind people that when it comes to appointments, ordinarily there's a difference between selection and appointment. And a perfect example of that would be in most countries where, let's say, the prime minister, after consultation with the opposition leader, would select a judge, but then the appointment would be made by the head of state, right? Whereas some people would just say that the prime minister appoints the judge. The prime minister does not appoint, they just select, and the appointment is made by the governor general. So that's why I usually like to make that distinction between selection and appointment. So the sole body that's responsible for selecting the judges of the CCJ is called the Regional Judicial and Legal Services Commission. And hereafter, I will be referring to that body just as the commission for ease. And this commission comprises of 11 commissioners or members. And this is where it gets interesting because the process of appointment of the president of the CCJ is slightly different from the appointment of the other judges. So let me start with the process of appointment for the other judges. The other judges are directly appointed by the commission itself by a majority vote. So, there must be at least a majority vote for that person, for those judges to be appointed, which is basically 6 out of the 11 commissioners. And like I said, these judges are directly appointed by the commission itself. So the commission has the sole authority in relation to appointment of these other judges. Now, as it relates to the method of appointment for the president of the court, the president is appointed by a 3/4 majority vote of the contracting parties, meaning the Caribbean heads of government that are signatories to the agreement establishing the CCJ. A 3/4 majority vote of those contracting parties on the recommendation, and these are the operative words, of the commission. So, in other words, the commission must first select or recommend the person for appointment as president, but the appointment will only materialize if 3/4 of the heads of government vote in favor of that appointment. And I find that to be quite interesting. And why I say that generally speaking, the process of appointment of the judges is unique is because this is something that you would hardly find, a process of appointment that you would hardly find in the Caribbean or anywhere else in the world, where most of the judges of the court are directly appointed by this independent body called the Regional Judicial and Legal Services Commission. And we will get to I suppose, the why I consider this body to be fully independent, a fully independent one, and not necessarily just giving the impression as it is independent, but the actuality that this body is indeed an independent body that is free from any political interference or manipulation whatsoever. So that yes.
So then the role of the politicians would only figure as it relates to the appointment of the president, and even so, they are only involved in terms of the appointment. So the commission would select someone for the presidency, and then the politicians, by means of the conference, they would be responsible now for the appointment.
That is absolutely correct, Colin. You hit the nail right on the head. So strictly speaking, the politicians, again, the heads of government of the CARICOM member states, do play a role, strictly speaking, in the appointment of the president of the CCJ, because again, they actually appoint the president, as I alluded to previously. And I must confess, Colin, that there's nothing troubling or concerning to me about this, because, like you correctly said, the appointment is not a standalone one. these heads of government still have to receive that recommendation from the commission. And I highly doubt that they would vote against this recommendation because, I just don't see it happening because the commission, I believe they would trust the commission's judgment to get it right. Because there would be a reason or multiple reasons why the commission would select this person in the first place. The same way, when I gave the example earlier, if a prime minister has to select a judge for a local court, it's highly unlikely that the head of state would go against that selection or recommendation. So in this regard too, I see this the appointment of the president by the heads of government as more of a confirmatory or rubber stamping role, than anything else. But however, the heads of government do not play any role at all in the appointment of the other judges, period.
I'm glad we got that out of the way early because that has been one of the arguments that I read that was being raised against the CCJ, that these politicians are involved in the selection of the judges, or these politicians can basically put who they want to run the CCJ. So that is really something that I'm glad that you would have cleared up. Talk to us a bit about the whole question of judicial independence and the safeguards that are there to preserve the independence of the judges of the CCJ.
Yes, and I think this is quite a natural progression from what we just discussed. So it leads perfectly into this. So I usually tell people that there are three main safeguards to ensure that CCJ judges remain free from and of political influence or interference. And the first one I want to discuss is nothing peculiar because it's something that local judges in the different CARICOM member states enjoy as well. And that's what we know as lawyers. We know it as security of tenure or judicial security of tenure. So CCJ judges have that too. So the office of a CCJ judge cannot be abolished once there is a substantive holder of that office. And a CCJ judge also cannot be summarily or arbitrarily removed from his or her office. So that's security of tenure, right? Your term in office is secured once you are in it. And they can only be removed from office if they're unable, Colin, to perform their judicial functions, whether it's because of mental illness or otherwise, or they could also be removed from office for misbehavior in office. And even then, Colin, if a CCJ judge is being accused of one of these two things, which is the inability to perform their judicial functions or misbehavior in office, there's still a rigorous process that must be followed before they can be removed from office. And that is a special tribunal has to be established to investigate the matter, etc. Very, very rigorous and tortuous process.
So that is the first safeguard, I would say, to ensure the independence of the CCJ judges, the security of tenure. The other two safeguards, Colin, are quite peculiar, however, and the second one is something that we discussed earlier. The first thing we discussed, the method of appointment, and I want to delve into this a bit more to show why, like I said earlier, the commission is really free from the commission, just like the judges, is free from any political interference or manipulation. So let's go to the method of appointment as a safeguard. So the commission, like I said, recommends the persons to be appointed as president and directly appoints the other judges. But what are the specific, what about the specific composition of the commission itself? Who are the members? And to answer these questions, the president is the chairman. The president of the CCJ is the chairman of the commission. Two persons are jointly nominated by the Organization of the Commonwealth Caribbean Bar Association and the OECS Bar Association. One chairman of the Judicial Services Commission of a contracting party, and there's a rotation every 3 years in alphabetical order. So it may start off with, a chairman, the chairman of the Judicial Services Commission from Antigua. Then it may go to, let's say, Barbados, in the next 3 years, and so on. Then there's one chairman of the Public Service Commission of a contracted party. And again, there's a rotation every 3 years, but in reverse alphabetical order. That is to say that the first chairman of the Public Service Commission of Trinidad and Tobago, and then, it goes in reverse alphabetical order every 3 years. Then there are two persons from civil society jointly nominated by the Secretary General of CARICOM and the Director General of the OECS following consultations with regional non-governmental organizations. Then we have two distinguished jurists jointly nominated by the Deans of the Faculties of Law in the Caribbean and the Chairman of the Council of Legal Education. And then we have two persons jointly nominated by the Bar and Law Associations of the CARICOM member states or the contracting parties. So you see that there are no politicians, right, for the membership of the commission itself. And
exactly.
There's absolutely no political involvement in determining the membership of the commission. So politicians, even apart from the fact that they're not members of the commission, they can't determine they also cannot determine who members of the commission will be, right? Completely free of any political interference. And that is why the judges of the CCJ themselves are also free from political interference. So that's number 2, Colin. That's the second safeguard.
Oh, that's impressive.
The final one,
it's very impressive. The drafters and the framers, they had such foresight to put things in place to ensure that there would be no political interference.
Colin, let me tell you how impressive it is before I go on to the what I consider to be final safeguard. It is so impressive that legal scholars and experts outside of the Caribbean region have suggested that this method of appointment be a model to be used for the appointment of other judges for international and local courts across the world. Wow. This particular method that is used to appoint judges of the CCJ.
And I can definitely, and it's well deserved. Well deserved.
Yes, absolutely, Colin. And I could share the literature and opinions with you once this is finished. So let us move on now to the final, what I consider to be a final safeguard to ensure independence of CCJ judges. And this is the remuneration for the judges, or the salaries of the judges. So the contracting parties or the heads of government establish a US $100 million trust fund, out of which the CCJ judges receive their remuneration, and the court's operations are financed. Granted, the heads of governments have to dip into their respective consolidated funds to ensure that this trust fund remains in existence. However, once the monies are placed into this trust fund, CCJ judges will not be at the mercy of these contracting parties for their monthly salaries. So what this does, Colin, is that it ensures that CCJ judges are not unnecessarily concerned about heads of government tampering with or withholding their remuneration while they are in office. Furthermore, the salaries and terms and conditions of the service of the judges cannot be altered to their disadvantage during their tenure. So what this does is that this strengthens judicial independence. Judges of the CCJ don't have to wait on their monthly salaries from the government really directly, because there is this trust fund that has been established out of which they will be paid. So those are the 3 safeguards I consider, Colin, that will ensure the independence of the CCJ judges. And when you take all of these safeguards together collectively, the CCJ is essentially what I like to call a judicial fortress. The CCJ actually, Colin, is regarded as one of the most insulated or protected courts in the world from any political manipulation or involvement. It's just a fact,
That is so excellent that you have broken it down so nicely for us. And I know my audience will have a very clear and cogent understanding now of all of the relevant protections that are in place to insulate the judges of the CCJ. Now we want to move on, because I know Barbados is in fact putting its money where its mouth is and is walking the talk in this regard whereby Barbados also has the CCJ as its final court of appeal. So I can think of no better person than a Barbadian national to talk to us about what are the benefits associated with having the CCJ as a final court of appeal.
Yes, very good question, Colin. And I want to discuss most of the practical benefits because we have to be practical too, not just in theory, but the practical benefits that actually accrue to
Definitely.
Commonwealth Caribbean citizens, our CARICOM citizens. Because that's why the CCJ was really established. It was established predominantly to benefit CARICOM citizens. It's our court, so well, the first benefit, of course, I would mention is that the CCJ is here to create this indigenous and richer Caribbean jurisprudence. Now, I always have to remind people that just because jurisprudence or decisions come from the Privy Council, it doesn't mean that it's not Caribbean jurisprudence because it's jurisprudence for Caribbean jurisdictions. So it's still Caribbean jurisprudence if it comes from the Privy Council. So that's why I deliberately said indigenous and richer Caribbean jurisprudence. And what do I mean by that? You need a court, which is what the CCJ is, that is more attuned to our Caribbean social, political, economic, and cultural realities. We would know, Colin, that the law does not exist in a vacuum. As a matter of fact, the law itself is influenced by different contexts, whether it be the same social, political, economic, or cultural realities, etc. So yes, when judges are making decisions, they have to apply the law, but they have to apply the law within certain contexts. And which better court to do that for us than the Caribbean Court of Justice? And I would just like to give two examples. I remember speaking to a very prominent senior counsel in Trinidad, and I was interviewing him, and he told me that the Privy Council, I think a few years ago, was making a decision in, which necessarily involved the president of Trinidad and Tobago. And one of the judges at the Privy Council, made mention of the president as a he. But at that point in time, the president was and still is a she, right? So something as simple as that shows that the some of the judges of the Privy Council may be far removed from our realities, and sometimes you may be surprised how damaging or fatal something like that could be when you're making decisions for all of these Caribbean countries. And that leads me to my next example, which is I remember reading a particular case where the Privy Council was dealing with a matter, I think, from the same Trinidad and Tobago, your homeland, Colin. And basically, the Privy Council was forced or constrained to defer to the Court of Appeal of Trinidad and Tobago simply because it said that it said it was not in a position to know the particular context in which the matter came out of, and therefore they felt as though the Court of Appeal of Trinidad and Tobago, because it was actually in Trinidad, would know what is best. So it was necessarily forced to just defer to the Court of Appeal of Trinidad and Tobago, which should not be the case, Colin. And that is why you need this regional Caribbean court like the CCJ. And I mean, I obviously, based on the last example that I mentioned, that would have never happened with the CCJ because the CCJ itself is based in Trinidad, right? So the CCJ can't say that it's not aware of the context in Trinidad and Tobago, and it could do the same for the other Caribbean jurisdictions as well because of its proximity and its positioning in the Caribbean, So that's one benefit, and I think is a very important benefit, Colin. The second benefit I would say is that with the CCJ, there's indisputably greater access to justice. And I know when most of us speak about access to justice, we think about, a person being able to afford a lawyer so that they could be represented before the court. But access to justice has been given based on the rule of law, a more liberal meaning than that. So no access to justice could be, in a geographical, technological, and financial sense. And I want to discuss all of these. And so first, geographical. Like I said, the CCJ is based in the Caribbean, more specifically Trinidad and Tobago. So therefore, it is very easy to get to the CCJ, whereas it would not be so easy for a litigant to get to the Privy Council, which is based in the UK. And that all of these actually tie in together, because it then leads me to the technological aspect of the access to justice. So you would know, Colin, that the CCJ is also a futuristic court, and the CCJ was using technology to advance access to justice even before COVID came, whereas most courts are only now using technology because COVID came, but the CCJ was doing that way before COVID came. So now a litigant or a person who feels aggrieved and wants to go before the court does not even necessarily have to be in Trinidad. It could be done virtually or online, and they could be represented virtually as well. Whereas I think for the Judicial Committee of the Privy Council, you you can watch the proceedings virtually, but I think the lawyers actually have to be physically there in the UK. And the problem with that is, and this leads to the financial aspect of the access to justice. The problem with that is that it's going to be very, very costly for a Caribbean person, more than likely, who wants to go to the Privy Council. It is going to cost a lot, because you have to look for accommodation. Of course, their currency is much higher, and all these things have to be factored in as well. So it is more costly, and no one can dispute that, to go to the Privy Council than it is to go to the CCJ. And to be quite honest, I don't think that if we have a court that was set up for our benefit, that CARICOM citizens should be deprived of this tremendous benefit when it is there, at our disposal. Access to justice, as you would know, Colin, is very important, because it's a component of the rule of law, and it could really make or break if a person, if a person actually gets, or is going to get the justice that they so deserve. So that's why I say, for the CCJ, there's greater access to justice geographically, technologically, and financially. So the next benefit, the practical benefit, Colin, I would say, is that the CCJ has a relatively expeditious delivery of judgments. And we would usually say in law that justice delayed is justice denied. That's a famous legal maxim. But with the CCJ, there's an outstanding record as it relates to dealing with cases in a timely manner. Usually, the CCJ is the court that usually has to chastise and scold the Barbadian local courts for not delivering their judgments on time with the unreasonable delay. So with the CCJ, there's no delay or denial of justice in that regard. Very expeditious in delivering and disposing of cases. And then lastly, and more generally, Colin, I want to tell people that when you watch the CCJ's hearings or read its judgments, you can actually see and feel that serious sense of commitment that it has to the Caribbean region and to us as Caribbean people. And I also think that that's very important, and it also goes back to that indigenous and richer Caribbean jurisprudence. So those, I would say, Colin, to me, are the major benefits that would accrue not just to CARICOM states, but the citizens thereof, of having the CCJ as a final court of appeal.
Thank you so much for that, Rico. At this point, we'll take a quick break, and we'll be right back. Welcome back, and thank you for staying with us. Rico, before the break, you gave us a really nice breakdown in terms of the benefits. And I'll tell you what stood out to me in terms of the accessibility, as opposed to having to travel all the way to London. We have the court right here. In my case, it's just a few miles away in Port of Spain. And also the whole question of the timeliness of the delivery of judgments. All right, because the CCJ has continues to deliver its judgment in record time, and it also makes use of all the available technology to make it as simple as possible for persons who may be residing in other islands to be able to have full access to the court. Now, I want you to talk to us a bit about some of the arguments that you are familiar with that persons normally use when they are talking against the CCJ.
Yes, Colin, and this is my favorite part right here. This is what I love to discuss. Because quite frankly, I really cannot find any arguments, in my opinion, that are convincing enough against having the CCJ as a final court of appeal. So what I will do is that I will highlight some of the arguments that people usually make against having the CCJ as a final court of appeal, and then I would respond to them and show why I don't think that they're convincing enough. So the first one, again, and I think this, if one of the arguments against the CCJ had to be the strongest, it is this one, but I still don't think it's strong enough or strong at all. And this is the susceptibility, which we discussed, the susceptibility to political manipulation. And I showed you already, Colin, extensively why the CCJ cannot be or is not susceptible to political manipulation. But if that was not convincing enough for most of the listeners, then I will go even further. And I will start off by saying this. Simply read the CCJ's judgments. Period. Especially the public law judgments. Because more often than not, and I would say like 95% of the time, the CCJ rules against Caribbean governments. So you can't come and tell me that the CCJ judges are susceptible to political manipulation when the proof is in the pudding. There's actual evidence and results to show that majority of the time, and I mean overwhelming majority of the time, they rule against Caribbean governments. That ends the argument and puts it to rest. Also, I would go further and say that in a Jamaican case coming from the Privy Council itself, the case of independent Jamaican Council for Human Rights and Marshall Burnett, this was decided a few years ago. The Privy Council itself acknowledged that the agreement establishing the CCJ is a serious endeavor to establish a court of complete independence. So, and this is interesting, Colin. So here you have the Privy Council, which some people say would be more independent than the CCJ itself, saying that the agreement establishing the CCJ, is a serious endeavor to establish a court of complete independence. Basically saying, therefore, that the CCJ is a court of complete independence. Right? So the same court that people are saying is more independent than the CCJ is actually in favor or supports the complete independence of the CCJ or acknowledges it. Also, I would say, Colin, that scholars, and I told you this already, scholars and experts outside of the Caribbean region have said that the safeguards for the independence of the CCJ judges should be used as a model for other international and local courts across the world. And that is significant. If persons from on the outside could look on and see, that we do have a court of complete independence, like the Privy Council said, but we ourselves cannot acknowledge it. So I think, Colin, that sometimes why persons on the outside looking into the Caribbean could look and realize that we have a court of complete independence, but we ourselves can't realize is because of what I respectfully call sometimes blissful ignorance. Sometimes we just like to jump on a bandwagon, and sometimes we just have no knowledge of the actual processes or work of the CCJ, but yet we think that what is on the outside, meaning the Privy Council, is better than what we have on the inside. The next argument that people usually raise against the CCJ is that they may have concerns about the quality of the judges. So I just want to lay this argument here to rest as well, because you have to satisfy certain criteria to qualify as a CCJ judge. And I find very stringent criteria as well. So the CCJ agreement states that regard must be had to the criteria such as high moral character, intellectual and analytical ability, sound judgment, integrity, and understanding of people and society. Apart from that, at least 3 of the judges of the CCJ must possess expertise in international law. And of course, this would be more relevant for the CCJ's original jurisdiction, where it acts as an international tribunal. But you would appreciate, Colin, that as a final court of appeal, international law may also become relevant, especially when you're dealing with constitutional matters and so on, and the relationship between international law and the local domestic law. So that's also is important for both jurisdictions, the original and the appellate jurisdiction. We also have we also have judges from all across the globe who practice and taught law in different countries and legal systems. So, for instance, Colin, a former judge of the CCJ, retired Justice Hayton, he was from England. And Justice Hayton was actually one of the leading scholars, if not the leading scholar, of the law of trust in the UK. And we had him as a judge here. We also have currently Justice Witt, who is from the Netherlands, which is a civil law system. And we have two former presidents of the CCJ who are members of the Privy Council. And one of them was also a former president of the United Nations International Criminal Tribunal for Rwanda. And that president is Justice Dennis Byron. So this is the caliber of judges, Colin, not just from inside the region, but outside, that we have at the CCJ at some point in time. And most importantly, the CCJ recently became the first court in the Caribbean region to be accepted into the International Consortium for Court Excellence. And this is not something that just happens because, you are a court, Colin, or, in order to be accepted into this consortium for court excellence, a court must demonstrate a commitment to excellence using a particular international framework for court excellence, which is a quality management system designed to help courts consistently, which is the operative word, improve their performance in 7 core areas. And these areas include court management and leadership, court policies, court proceedings, public trust and confidence, user satisfaction, court resources, and affordable and accessible court services. Some of the things, Colin, that we discussed already, right? So, and this is significant. So no one really can seriously question the quality or high caliber of judges that we have at the CCJ. And then the final one I usually hear, or an argument against having the CCJ as the final court, Colin, stems from the second one. And this one is the quality of judgments, concerns about the quality of judgments that the CCJ may render. And I want to say here, Colin, that the quality of judges informs the quality of judgments. So if we just if I just prove that we have quality judges, then you know that the judgments would be quality as well. So generally, I find the CCJ's judgments to be sound and well-reasoned. I don't always agree with every single one. Sometimes I may agree with the outcome, but not the reasoning. Other times I may agree with either I wouldn't agree with either the outcome or the reasoning. But just because I disagree with one or two, does it mean that they're all terrible judgments, or that the CCJ is generally incapable of producing meritorious judgments? I think not. And if we use this as a litmus test, then we would have to say the same thing about the Privy Council or any other court in the world. If we are dissatisfied with one or two judgments and we think that, that particular court is not capable of producing judgments, then it can't just be the CCJ. It would have to be almost every court in the world, because there's some judgments, Colin, from the CCJ, from the Privy Council, that I could look at and easily disagree with. But that doesn't mean I think that the Privy Council is incapable of producing sound or well-reasoned judgments. So it can't just be the CCJ in this regard. If it's for the CCJ, it has to apply for all. And another strong point in relation to quality of judgments, and I think this is one argument or counter argument, I should say, that causes the arguments of the critics to fall flat, is that as of late, the Privy Council itself has been favorably citing and relying on some of the CCJ's decisions. So if you are going to tell me that if you're going to tell me, Colin, that the judgments of the Privy Council are of high quality, but not the judgments from the CCJ, how do you explain or rationalize the fact that the same Privy Council that you are praising is relying on judgments from the CCJ to arrive at some of its decisions, and favorably too as well, right? So those are the three arguments usually, Colin, that I hear against the CCJ. Just to recap, the susceptibility to political manipulation, the quality of judges, and the quality of judgments. But like I just explained again extensively, I don't find them to be convincing at all.
Excellent, Rico. So many persons like to harp on that whole idea, like we said earlier, about political influence. I think that is one of the major ones that persons like to use. The quality of judges and all those different things. Some people may talk about that, but the main one, at least in our local context, people like to talk about is that whole question of the influence of the politicians. So I hope that this episode will put that to bed, and that persons will know that the CCJ is really and truly completely insulated as much as is humanly possible from that whole question of the influence of politicians. And not only that, the same Privy Council that everyone is looking to is now citing our decisions in the Caribbean and is praising us for our independence. I think that is so ironic, you know. That is so ironic. So, Rico, I think this is a good time to bring this episode down, bring the curtains down on this episode. I don't know if you had anything else that you want to just highlight about the CCJ.
Only a few things I would like to add here, Colin, as we wrap up. And I just want to say that the common thread, when you go through all the arguments against having the CCJ as a final court of appeal, you would find one common thread, and that is distrust of our own Caribbean people by our Caribbean people. Right? And is really distrust of our own people to have sound and impartial judgment. And I think, Colin, that is a serious and deep-rooted problem. And I think that is what we need to fix and address first before, any other country will accept the CCJ as their final court of appeal. And finally, whenever I discuss the CCJ and the pros and cons of the CCJ, I always end with this because I find it to be very powerful. And it's a statement from one of the former law lords of the Privy Council, Lord Hoffman, who was a very prominent one as well. And he said in 2003, when he was in Trinidad and Tobago, at a law association, I think it was a dinner or something like that, some kind of event. He said, and I quote, "Although the Privy Council has done its best to serve the Caribbean, our remoteness from the community has been a handicap. My own view is that a court of your own is necessary if you are going to have the full benefit of what a final court can do to transform society in partnership with the other two branches of government." And he made a statement, Colin, before the CCJ was inaugurated. Now it has been inaugurated, and so many years have passed, and most of our CARICOM heads of government are not minded or willing to use a court that was established and set up specifically for all of us by our Caribbean forefathers. And I will leave it there, Colin. I will leave it there. And I will just ask, what is the problem? Why are we so distrustful? What are we afraid of? And I'm just going to end with those burning questions.
Definitely. I just like to put it on record that I am in favor of the Caribbean Court of Justice. I believe in the work of the CCJ, and it pains me that my nation, where the CCJ is located as its capital, has failed to accede to the final, the appellate jurisdiction of the CCJ. And I look forward to the day when that historical wrong will be corrected. So with that, on that note, Rico, I'd just like to sincerely thank you for all that you have contributed to this program. And I also like to thank you for your support of this program thus far. And who knows, we'll have you back on again sometime. All right? So thank you very much. Now,
Thank you very much, Colin, and also extend my gratitude to Leonardo, even though he's not here, for having me. I really enjoyed the discussion, and I really love what you guys are doing. You know, public legal education, which I think is important, and also in its own way advances the rule of law. So kudos to both of you guys. Keep it up. Job well done.
Now, this has brought us to the end of another episode of the Legal Corner podcast series. I'd like to remind you to check us out on social media if you haven't already done so. Our Facebook page is the Legal Corner podcast series. On Instagram, we are at the Legal Corner. We are also on Patreon if you're interested in supporting our work. If you enjoy the show, we'd like to ask you to share it with your friends and family so that they can also benefit from the information that we are sharing by means of this podcast. Feel free to leave us a rating and a review on Apple Podcasts or Podchaser, as this will help other persons to discover our show. We'd also love it if you subscribe to our podcast so that you won't miss any of our future episodes. Special thanks to the members of our promotional team who are helping us to get our message out. Bye for now, and God bless.
Thank you for listening to the Legal Corner podcast series. For more information, please visit us at our Facebook or Instagram pages or send your comments to thelegalcornerpodcast@gmail.com. We look forward to hearing from you.